So what do you make of this case? Do send us your comments. How should South Africa, I suppose, deal with this claim of currency manipulation? Send us your thoughts. WhatsApp 072110554. Call us on 01059461010. You can also engage on X at Newzroom 405. Here to discuss the matter with us, SACP spokesperson Mbulelo Mandlana, First Money Source Executive Director Reg Nkosi, legal analyst Mpumelelo Zikalala, as well as Ramsey Sihohoba Incorporated commercial law head Refuwe Tuwela. All right, good to have you, gentlemen, and thank you very much for your time. Let me begin with us here in the studio, Mbrelo. What would be the implications, one, of the Constitutional Court saying the Competition Commission doesn't have jurisdiction, or what would be the implications if it goes the other way?
Well, we are hoping that the Constitutional Court vindicates the Competition Commission, because as far as I'm concerned, the Competition Commission is our best bet to deal with the bottom issues, to arrive at the base and the source of the issues that are in the collusion of the banks. Because whatever determinations may have been arrived at earlier, it is quite clear for everyone that there is a lot of wrongdoing. The technicalities that are involved in the investigation, in the standard of proof, and so on and so forth, are technicalities that the Commission may not have been able to meet in the earlier parts of the case, but we believe that in the ConCourt, they should be able to meet those standards and indeed vindicate the South African government in policing, really, this misbehavior in the banks.
Yeah. But Reg, is the Competition Commission equipped to deal with these instances of currency manipulation by big banks, especially at an international level? Do they have up-to-date information in terms of the complexities? Do they have up-to-date information in terms of guidelines that seek to prevent this kind of behavior? Baresh, that's for you.
Well, firstly, I worry that the Constitutional Court will have... Yes? Can you hear me?
Yes, we can. Go ahead.
All right, thanks. Yeah, I worry that the ConCourt will have a clear understanding of this matter. But I think from any expert, it's a lot easier. And it was quite shocking to learn that the Competition Appeals Court thought that there isn't much jurisdiction for the Competition Commission over these banks. Remember, the rand is a national currency, and it does affect citizens of this country. Any person tampering with this country, in a way, by tampering with the rand, is tampering with South Africa, that person might, quite frankly, be liable for tampering with the currency. Wherever they are, I do know that the rand is traded offshore as well as domestically. Even if the rand is being traded offshore, in my view, in my considered view, that still does affect South Africa, and therefore whoever plays around with the rand must be held accountable. And in my view, the Competition Commission has that jurisdiction. But as to whether the ConCourt will find the same is anyone's guess. But I hope they'll come to understand that this is so simple from an economic perspective, and perhaps even just other social perspective, that the currency, which is the rand, is owned by South Africa, and therefore any person working on this rand must conform with the rules, regulations, and the laws of the country. Yeah. However, we're going to see how the lawyers look at it. But in my view, it is a straightforward case that South Africa is, in fact, has the authority to engage these banks that have been manipulating the currency from as early as 2001.
Yeah. Let's hear from some of the legal minds that are joining us. Maybe they'll assist us here. Kuzeni, talk to us here, the technicality of what is being discussed. I mean, you and I would have discussed jurisdiction before in terms of whether the matter has been brought to the correct court. But there's also an argument of jurisdiction on whether or not the Competition Commission has jurisdiction over international banks. How do the courts approach those two matters?
Hey, good evening to my fellow panelists. That's a very important one. Remember, when you go to court, use the tools that you have. So the Competition Commission in the Competition Appeals Court or tribunal will then come to the conclusion of saying, do I have the instruments of holding these individuals accountable? Or should, when the matter came about within the respective parties, it should have gone to an ordinary court, meaning a normal civil court, putting through the Competition Commission or maybe the South African Reserve Bank, and then say, I want to make sure that I'm able to hold these banks accountable through your normal competition laws that would have been applicable. Now, I think the reason why they chose in that particular tribunal is that, one, you're dealing with specialists who are going to understand it better. When you come to them and you say, this is the type of the collusion which was taking place and non-competitiveness which was there, they would have a better understanding as to what it is. But if you want to separate it between the two, the narrow interpretation would be to say, let's stick to what is written down in terms of the powers. Is it a South African company? Is it a company which is registered in South Africa? If the answer is no, then you have no jurisdiction. But if you want to expand it, then you say, are you getting any benefit by applying or participating in this part of activity? If the answer to that is yes, second question, is your participation, does it have an impact on the ordinary South African? If the answer to that is yes, then it means whatever courts that are there, including, or the most important one in this case, the Constitutional Court, when considering whether it should rule a particular conduct as being lawful or not, must consider the impact and the application of such, and also taking into account that we're not dealing with something that we have developed jurisprudence over the years. It's the first time in which a matter like this is coming to the courts. There are going to be mistakes here and there, but let's look at the bigger picture. Who are we trying to protect? Members of the public? Let's do that first before we get bogged down to the technicalities.
Yeah. Refu, the other banks, especially local banks, are arguing that there are no constitutional issues that are implicated here. Regin Kosi also raising that particular issue, saying he would find it quite strange that the Constitutional Court would reckon there are no constitutional issues implicated here. What are those issues in your view, I suppose, in your analysis?
Good evening to your viewers, and thank you for posing the question. Good evening to my panelists, to my fellow panelists as well. Look, I don't think that the issue of constitutionality is the biggest issue here. And I think the Competition Commission was correct in its application. And what do I mean is that they firstly founded this application on the merits of the case, and they are then alleging that there's been collusion and there's been price fixing, and those two those two main issues, in my legal opinion, it finds jurisdiction, or it's a basis for jurisdiction. And then if you then look at the Competition Commission, it's in Section 3, right? I think it's Section 3, subsection 1. It then possibly gives the Competition Commission extraterritorial jurisdiction, particularly as it pertains to matters that affect the South African economy, whether in the Republic or outside of the Republic. So that is a technical issue that I suppose, maybe the Competition Commission Appeal Court might have overlooked, to say, to what extent then to what extent is then this this question of economic activity, lead to. So, and I suppose possibly that's how the other 17 banks out of the 21 were, I suppose, in this regard, the matter was found in their favor. But in terms of then the Constitutional Court, it will be very important for them to then actually adjudicate this matter properly, to say, when we're then looking at this extraterritorial authority that the Competition Commission supposedly has in terms of the Competition Act, to what extent then does it allow them to be able to litigate against countries that are in foreign, firms or companies that are in foreign jurisdiction? Because if they don't get it right, it would essentially mean that each and every time that matters like this happen, the Competition Commission would have to litigate in countries that these companies come from, and it wastes time. Secondly, it would be very costly, and thirdly, you can imagine again, just the amount of time it would take just to even litigate. So I think it would be very important from that perspective for the Constitutional Court to really clarify this extraterritorial authority or powers that the Act confers upon the Competition Commission.
All right. Let's talk a little bit about this particular matter in terms of the economy of South Africa, right? There are others, associations affiliated to banks, not necessarily regulators, who are saying South Africa cannot afford a crisis of confidence in the banking system that so far has been very robust, very good. It works with government, it supports government. In fact, if that particular system is compromised, government will even have difficulty going to the banks to raise money because it will become really, really expensive. They've been working with government, for example, to get government off the grey list. So these are institutions that are patriotic. These are institutions that are for the economy of South Africa. They are for the improvement of the image of South Africa as far as investment is concerned. From a communist point of view, what do you say to that?
Well, it's very convenient for those people to say that. If this collusion, as it is alleged by the Competition Commission, has been going on for more than 10 years, the fact that these experts, together with the banks, commonly share a perspective that they must be let off the hook, brings them to question. The first point is, as far as we are concerned as a Communist Party, the fact that the two of the banks that have acted incorrectly in this instance have been fined, for example, the 70 million for the City Bank and the 40-something million for it's not Standard Chartered. What does that tell us? It tells us they know and they are admitting that something systematic is occurring. It is so systematic that they are wanting to come forth and be witnesses of the state. Now, in whose interest is it that those banks and those financial role players, other than these two, must be let off the hook, such that they must not be put to question in the name of not tainting the image of the South African financial system? If the name of the South African financial system was so impeccable, we shouldn't be having this discussion. In fact, as the Communist Party, we are saying the problem is not whether or not there are fines or there are no fines. What we are looking for as a Communist Party is a thorough-going analysis of the state of affairs in terms of the big finance monopoly capital in South Africa, what role it is playing, how it is manipulating the rules, how it is betting on the weakness and the lack of sophistication of our investigative system and the small size, for example, of the Competition Commission, thinking, therefore, that it can manipulate the cross-border financial systems in order to increase their position at the expense of the South African state to source tax in order to help people in South Africa. And in that way, act a lot in favoring their positions financially at the expense of the South African government. So for us, the question is not whether or not we must save the credibility of the banking system when the banking system has done nothing indeed in this instance to prove that it is worth saving. 0105946010 is the number to dial if you want to get involved in the conversation. WhatsApp 0721105584. We've got Alfred in Tembisa. Alfred, good to have you. Good evening and welcome.
Good evening, Thabo.
Go ahead. What do you think should be the approach here? There are some who suggest that maybe this is a time for a state bank so we could deal with these issues of currency manipulation by banks.
You know, Thabo, as a person who has grown up in Tembisa, I'm not surprised with the attitude of the banks, because this bank has been doing as they wish. But also I blame the government since 1994, because the government has not done a fundamental radical departure in terms of the transformation of the financial institution. And the banking is one of them. But remember, because my point is that this is the same bank that they have colluded under apartheid to exclude the African majority from financial assistance, financial benefit versus the white minority people in the country. So the attitude is still the same. Nothing has changed at all. So I blame the government that the government have not taken a control and put the system in place to fundamental and radically transform this financial institution, because they still continue as they did against during the apartheid system, right, to oppress and make sure that majority of the black people they are not financially included in terms of any whatever activities of the country. So this thing, I'm not surprised at all.
Alfred, I appreciate your call. Thank you very much, Alfred, calling us there in Tembi. So you can also call us 010-594-6010. Otherwise, you can drop us an X at Newzroom 405. We'll continue the conversation in a moment. Stay with us. Back on the late edition. Thanks for staying on the conversation tonight around, of course, the matter that is in the Constitutional Court for the next couple of days, where the Competition Commission is arguing jurisdiction in the matter that affects some local as well as international banks in what is now known as currency manipulation between 2007 and 2013. We have Mbulelo Mandlana in studio with us. We've got Reg Nkosi, Mpumelelo Zikalala, as well as Refuwe Tuela with us. And Muremedi is joining us on the line in Pretoria. Muremedi, good to have you again. Good evening, rather. Go ahead.
Yeah. Good evening, my brother. Good evening.
Yes, go ahead. What do you think? What do you make of this case?
Yeah, first of all, I would like to really congratulate the Competition Commission with what they are trying to do. But now, this is the time that South Africa, must show that we got laws in our country. The Competition Commission, they're doing the right thing by going to apex court. We cannot lose this case. We cannot allow to be ruled by other countries with their own banks in South Africa. This is the time that we must show that there is loss. Another thing I want to say, I used to talk about the Reserve Bank in South Africa. There's also Botswana Bank, where the bank is controlled by the government. In South Africa, our Reserve Bank is controlled by shareholders. So it seems as if really we are not having control of these banks. And then until in South Africa we become firm with our laws, we become firm as to how do we operate our our finances, then we're going to come all right. At the moment, we are as consumers, we really felt what happened, what the bank did to us. We are really, really grieving here. Yeah. We are really wishing that the Competition Commission really get support, and this thing we must win it. Really, we must win it. We must stand with them.
Murabit, I appreciate your call there in Pretoria. Paraj, let's look at this. Even what Murabit is raising around Treasury and around the South African Reserve Bank. You heard one of the analysts earlier saying that the regulator did its own review of these processes and they found very, very little participation, particularly by the local banks. Now, the local banks argue that why would we destroy an economy that which we are part of? In fact, we've partnered with government to fix the Financial Action Task Force grey list issue, which has found the banks complied with international regulations and best practices. So they're saying they've found us to be proper in terms of what we do here in the country. They're saying South Africa complies with international regulations, so they've got to be tested by Treasury that they are well regulated. There is no way they could be the same banks that could participate in destroying the economy of South Africa.
Well, it sounds so, but I think what we know of banking, not just in South Africa, but elsewhere, they do practice these activities, which are quite frankly very unacceptable. And remember, like I said earlier, we had a similar issue in 2001 and later in 2014 and so on. Banks do not really care about what you think is, the partnership between them and the government. They continue to do as the profitability issues demands of them. So they're more driven by profits than the notion that the South Africans are working with government and so on. They don't think in that fashion. And after all, they think individually. Each one participates on its own. Remember, Maria Ramos not long ago acknowledged that ABSA was, I'm afraid, part of this collusion. And why would ABSA be part of this collusion if ABSA is a citizen working with government? It tells you then that I'm afraid they don't think in the manner we think. But also, I think we should understand this. The Reserve Bank should have been regulating these activities quite well. I'm afraid the Reserve Bank doesn't, which is very, very sad. It doesn't do that as it should. In our view, the Reserve Bank is vested with significant tools to regulate this banking, but they've been off for whatever reasons. So I think banks are involved in this, and they can actually collapse the very economy, and they will raise it again in the manner they deem appropriate. So we cannot think that they are here as good citizens. They aren't. They've been participating in quite poor ways with regard to banking in South Africa. Most people are actually not aware that the South African banking system is one of the worst in the world. However, the media wants to put it as such. From an economic perspective, one of the reasons why we find ourselves in this economic mess is because they do not give credit to SMMEs, including Black people or African people, if you want. There's too little of SMME support from banking system in South Africa. Much of the support they give is actually to the large European-owned businesses, not the African business. So the notion that they're all South African and so on is quite misplaced. By the way, just before I get off, the rand is a public good. Banking systems are supposed to be public goods. They're supposed to be goods to be offered by the state. And they're offering these services on behalf of the state. However, they think that it's their business, not knowing essentially that this banking system is supposed to be a public good. However, the way they behave as if this is just their own activity that they founded.
Thanks, Brother. Zikalala, the question of cartel behavior, I mean, they're saying you need to clearly prove there is common anti-competitive objective by all the banks, where the banks were pursuing a common economic objective. How difficult would that be to prove in a court, especially considering that, I mean, the Reserve Bank has done their own review and they say, well, some of the South African banks barely participated in that chat box of Bloomberg.
Well, that becomes the nub of the problem, because the issue, the process that you have to prove is to say, but for the action of the banks, this is the consequence of the results that you have suffered. So if there's anyone who's not going to participate, that chain or link is then broken, then you can't prove your causation properly. And mostly in the people that you have identified, you're not going to be able to prove whatever that is there. So it's important for you, when explaining the harm that has taken place, to take the justices through the process of what was happening. And I think that was, I forgot why Job was doing that when explaining how the process is, explaining how those instruments are. But the nub of the submission being, at the end of the day, the only person that benefited in all of this is the banks themselves. The South African government did not benefit in terms of taxes. The South African community did not benefit. And there's no one who's coming to the aid of the South African public. So the poor, unsuspecting members of the public or South Africans that are engaging and trusting in these banks on a daily basis are the ones who are being exploited, not because it's economic terms, because the economic processes or the economic environment or ecosystem has been designed in a way in which it's going to derive maximum profits for those that are there. Now, the question is, which the Constitutional Court will have to answer, do you then say, because we do not have strict or concrete instruments that we can hold these banks accountable in, let's dismiss this matter and say that we don't have jurisdiction? Or you then say, let me use my powers as the Constitutional Court to say, at the end of the day, I can't let members of the public suffer in the manner in which they are suffering in. Yes, government may have to go and augment whatever the Competition Act is saying, but for now, let me come to the aids of the poor unsuspecting public and provide some sort of relief for them. They may not get individual relief in terms of monies in their pockets, but if you are able to punish these few individuals, then at the end of the day, you would have sent a very strong message to anyone that wants to participate in the South African economy to say, if you do so within the realms of the law, and do so by making sure that your business is ethical, and whatever that you do is going to be pure profits, not derived from any collusion due to the fact that you are the only one that understands the ecosystem that you are in.
Rafua, just a minute left, very quick one from you. The admission, I mean, the admission of guilt was also couched very carefully, I suppose, by those who admitted and paid the fines. But how much weight does that bring to this particular matter?
Yeah, no, look, that is very big. I mean, that on its own, goes to show the intention, and possibly it even goes to show the the manner in which most of these banks were dealing in bad faith, for the period in which this collusion has been going to. So the consequences could be enormous. In fact, they are going to be enormous, from the administrative penalties to possibly even, legal action from those people who would have suffered, as a result of, or rather would have suffered economically as a result of this collusion and price fixing. So the legal consequences could open doors like class actions from people that could actually directly relate the bank's actions to their economic loss or damage thereto. So yeah, it's quite significant.
Appreciate it. Bulelo, final words from yourself. I mean, there are those who would says, and of course it's a continuous debate in South Africa between the ANC, what could have influenced the depreciation of the currency in the country. Now, there are those who argue that, look, if you look at the broader changes in the global and domestic economy, you could hardly argue that it's the effect of what the banks did in 2007 and 2018. There are broader issues that have affected the change in the currency.
And usually that is said in order to justify a point that they must not be blamed for what was done. One of the things that are very interesting about banks, just before the Lehman Brothers collapsed the American economy, everybody said everybody was doing well. So we cannot trust that the financial sector are acting in good faith, the point that has been made by one of my panelists. Number three, the South African citizens may not, because of course of the hidden aspects of this particular collusion, which must be uncovered through this case. We cannot quantify what could have been lost economically from a taxation standpoint by the government. We cannot be able right now, until the case is solved, to determine what economic potential would have been lost as a consequence of the collusion, because there is nobody in this conversation at all who is denying that there was collusion. All the other people who are opposing the case being brought against the banks are saying there is other ways to deal with the matter except to confront the banks. Why should the banks be let off scot-free? As the Communist Party, we say, we must support the Competition Commission. Like I said at the beginning, they are our best bet in terms of the institutions of government that can help us with this, because clearly the Reserve Bank is not helping the Competition Commission. On the contrary, it is helping the banks.
Let's leave it there. Much appreciated. Spokesperson for the South African Communist Party, Mbulelo Mantlane. First Money Source Executive Director, Reg Nkosi. Legal Analysts, both Mpumelelo Zikalala, as well as Ramsey Sihohoba, Incorporated Commercial Law Head, Refuwe Tubela. Thank you for your engagement this evening.